Regulation, EU, 2016/679 of the European Parliament and of the Council, of the 27th of April 2016.
On the protection of natural persons with regard to the processing of personal data and on the free movement of such data, and repealing Directive 95/46/EC.
General Data Protection Regulation. Corrected, updated by C1 Corrigendum, Official Journal, L127, the 23rd of May 2018, p. 2, EU, 2016/679. Consolidated as of the 7th of November 2021. Chapter 1, General Provisions. Article 1, Subject Matter and Objectives. Paragraph 1. This regulation lays down rules relating to the protection of natural persons with regard to the processing of personal data, and rules relating to the free movement of personal data. Paragraph 2. This regulation protects fundamental rights and freedoms of natural persons, and in particular their right to the protection of personal data. Paragraph 3. The free movement of personal data within the Union shall be neither restricted nor prohibited for reasons connected with the protection of natural persons with regard to the processing of personal data. Article 2, Material Scope. Paragraph 1. This regulation applies to the processing of personal data wholly or partly by automated means, and to the processing other than by automated means of personal data, which form part of a filing system, or are intended to form part of a filing system. Paragraph 2. This regulation does not apply to the processing of personal data. A. In the course of an activity which falls outside the scope of Union law. B. By the Member States when carrying out activities which fall within the scope of Chapter 2 of Title V of the TEU. C. By a natural person in the course of a purely personal or household activity. D. By competent authorities for the purposes of the prevention, investigation, detection or prosecution of criminal offences, or the execution of criminal penalties, including the safeguarding against and the prevention of threats to public security. Paragraph 3. For the processing of personal data by the Union institutions, bodies, offices and agencies, Regulation, EC, No. 45, 2001 applies. Regulation, EC, No. 45, 2001 and other Union legal acts applicable to such processing of personal data shall be adapted to the principles and rules of this regulation, in accordance with Article 98. Paragraph 4. This regulation shall be without prejudice to the application of Directive 2000/31/EC, in particular of the liability rules of intermediary service providers in Articles 12 to 15 of that directive. Article 3, Territorial Scope. Paragraph 1. This regulation applies to the processing of personal data in the context of the activities of an establishment of a controller or a processor in the Union, regardless of whether the processing takes place in the Union or not. Paragraph 2. This regulation applies to the processing of personal data of data subjects who are in the Union by a controller or processor not established in the Union, where the processing activities are related to a. The offering of goods or services, irrespective of whether a payment of the data subject is required, to such data subjects in the Union, or b. The monitoring of their behavior as far as their behavior takes place within the Union. Paragraph 3. This regulation applies to the processing of personal data by a controller not established in the Union, but in a place where member state law applies, by virtue of public international law. Article 4, Definitions. For the purposes of this regulation. 1. Personal data means any information relating to an identified or identifiable natural person. Data subject. An identifiable natural person is one who can be identified, directly or indirectly, in particular by reference to an identifier such as a name, an identification number, location data, an online identifier, or to one or more factors specific to the physical, physiological, genetic, mental, economic, cultural or social identity of that natural person. 2. Processing means any operation, or set of operations, which is performed on personal data, or on sets of personal data, whether or not by automated means, such as collection, recording, organization, structuring, storage, adaptation, or alteration, retrieval, consultation, use, disclosure by transmission, dissemination, or otherwise making available, alignment or combination, restriction, erasure or destruction. 3. Restriction of processing means the marking of stored personal data, with the aim of limiting their processing in the future. 4. Profiling means any form of automated processing of personal data consisting of the use of personal data to evaluate certain personal aspects relating to a natural person, in particular to analyze or predict aspects concerning that natural person's performance at work, economic situation, health, personal preferences, interests, reliability, behavior, location or movements. 5. Pseudonymization means the processing of personal data in such a manner that the personal data can no longer be attributed to a specific data subject without the use of additional information, provided that such additional information is kept separately and is subject to technical and organizational measures to ensure that the personal data are not attributed to an identified or identifiable natural person. 6. Filing system means any structured set of personal data which are accessible according to specific criteria, whether centralized, decentralized, or dispersed on a functional or geographical basis. 7. Controller means the natural or legal person, public authority, agency, or other body which, alone or jointly with others, determines the purposes and means of the processing of personal data, where the purposes and means of such processing are determined by union or member state law. The controller, or the specific criteria for its nomination, may be provided for by union or member state law. 8. Processor means a natural or legal person, public authority, agency, or other body which processes personal data on behalf of the controller. 9. Recipient means a natural or legal person, public authority, agency, or another body, to which the personal data are disclosed, whether a third party or not. However, public authorities, which may receive personal data in the framework of a particular inquiry in accordance with union or member state law, shall not be regarded as recipients. The processing of those data by those public authorities shall be in compliance with the applicable data protection rules according to the purposes of the processing. 10. Third party means a natural or legal person, public authority, agency, or body other than the data subject, controller, processor, and persons who, under the direct authority of the controller or processor, are authorized to process personal data. 11. Consent of the data subject means any freely given, specific, informed, and unambiguous indication of the data subject's wishes by which he or she, by a statement, or by a clear affirmative action, signifies agreement to the processing of personal data relating to him or her. 12. Personal data breach means a breach of security leading to the accidental or unlawful destruction, loss, alteration, unauthorized disclosure of, or access to, personal data transmitted, stored, or otherwise processed. 13. Genetic data means personal data relating to the inherited or acquired genetic characteristics of a natural person, which give unique information about the physiology or the health of that natural person, and which result, in particular, from an analysis of a biological sample from the natural person in question. 14. Biometric data means personal data resulting from specific technical processing relating to the physical, physiological, or behavioral characteristics of a natural person, which allow or confirm the unique identification of that natural person, such as facial images or dactyloscopic data. 15. Data concerning health means personal data related to the physical or mental health of a natural person, including the provision of health care services, which reveal information about his or her health status. 16. Main establishment means a. As regards a controller with establishments in more than one member state, the place of its central administration in the Union, unless the decisions on the purposes and means of the processing of personal data are taken in another establishment of the controller in the Union, and the latter establishment has the power to have such decisions implemented, in which case the establishment having taken such decisions, is to be considered to be the main establishment. B. As regards a processor with establishments in more than one member state, the place of its central administration in the Union, or, if the processor has no central administration in the Union, the establishment of the processor in the Union where the main processing activities in the context of the activities of an establishment of the processor take place to the extent that the processor is subject to specific obligations under this regulation. 17. Representative means a natural or legal person established in the Union who, designated by the controller or processor in writing pursuant to Article 27, represents the controller or processor with regard to their respective obligations under this regulation. 18. Enterprise means a natural or legal person engaged in an economic activity, irrespective of its legal form, including partnerships or associations regularly engaged in an economic activity. 19. Group of undertakings means a controlling undertaking and its controlled undertakings. 20. Binding corporate rules means personal data protection policies, which are adhered to by a controller or processor established on the territory of a member state for transfers, or a set of transfers of personal data to a controller or processor in one or more third countries within a group of undertakings, or group of enterprises engaged in a joint economic activity. 21. Supervisory authority means an independent public authority, which is established by a member state pursuant to Article 51. 22. Supervisory authority concerned means a supervisory authority, which is concerned by the processing of personal data because a. The controller or processor is established on the territory of the member state of that supervisory authority. b. Data subjects residing in the member state of that supervisory authority are substantially affected, or likely to be substantially affected by the processing, or c. A complaint has been lodged with that supervisory authority. 23. Cross-border processing means either a. Processing of personal data, which takes place in the context of the activities of establishments in more than one member state of a controller or processor in the Union where the controller or processor is established in more than one member state, or b. Processing of personal data, which takes place in the context of the activities of a single establishment of a controller or processor in the Union, but which substantially affects, or is likely to substantially affect data subjects in more than one member state. 24. Relevant and reasoned objection means an objection to a draft decision as to whether there is an infringement of this regulation, or whether envisaged action in relation to the controller or processor complies with this regulation, which clearly demonstrates the significance of the risks posed by the draft decision as regards the fundamental rights and freedoms of data subjects, and, where applicable, the free flow of personal data within the Union. 25. Information Society Service means a service as defined in point B of Article 1, Paragraph 1, of Directive, EU, 2015/1535 of the European Parliament and of the Council. 26. International organization means an organization and its subordinate bodies governed by public international law, or any other body which is set up by, or on the basis of, an agreement between two or more countries,